And with that, we shall kick off this episode with business and immigration law updates. This portion of the show is a presentation of the Khurana Law Firm from Rockville, Maryland. To moderate this segment is attorney Kenneth Haber, who's also from Maryland. This morning, attorney Haber questions attorney Khurana on fiancé visas for USA citizens. Let's have a look.
Hello, I'm Kenneth Haber. I'm a former assistant United States attorney and I'm a former senior attorney in the Office of Inspector General of the United States Department of Health and Human Services. And this is the Capitol Forum. With us today is Ramesh Khurana. Ramesh, welcome.
Thank you.
Ramesh is a worldwide immigration attorney. He has clients across the world, from across the world, who have wanted to and have successfully immigrated to this country. He's very well versed in this field, and it's a pleasure to have him here to inform us concerning the visas for fiancés when they're being brought over to this country. Ramesh, welcome again.
Thank you. Thank you very much.
What is the K-1 visa, Ramesh?
K-1 visa is a fiancé visa. Now, there used to be a time when US citizens, they were able to bring their life partners after they got married. So they would file a petition and it would take about a year to bring their spouses, or else the fiancés, they would come to United States on a visitor visa, and then US citizen could file for change of status. But that was a very challenging task, because once you are telling the truth to the US consulate that you are already engaged to be married, and then you are applying for a visitor visa, then your intent has changed from non-immigrant to immigrant, and US consulate would most probably not grant such a visa. So now this is a comparatively recent origin, but not very recent, and under it you are bringing your fiancé, and then you are saying that you are going to get married with the fiancé within 90 days. So that is covered under K-1 visa.
So you can bring your fiancé over with the K-1,
Yes.
saying you're going to get married in 90 days.
Yes.
Then you can get an adjustment.
Yes. You got it. You are turning an immigration lawyer.
Well, I've been hanging around you long enough. But that doesn't always work. What if they're already married?
Yes, my dear friend, if they are already married, this K-1 visa is meant only when there is a fiancé relationship. If you are already married, then you can't say that that person is your fiancé, otherwise you are going to be in trouble. So if you are already married, then you have to file the regular I-130 petition and then bring your fiancé when the visa application gets processed.
How long does that take, though?
It takes anywhere between 8 months to 12 months.
So you're better off in terms of getting your fiancé over quicker if you're not married.
Nowadays in my practice I have seen even fiancé visa is taking much longer time than it used to take earlier. The time difference is almost nothing. Rather, I have started advising my clients, instead of bringing your fiancé on K-1, get married and file the regular petition. Otherwise they have to bring the fiancé on K-1 visa, and when the fiancé is here, you have to file again change of status within 90 days. And I would have started advising, better you come on green card. I think it works much faster.
That's interesting.
Again, it always depends upon the processing time. If processing time changes for the fiancé visa, if I'm sure my client is going to get the job done within 4 months to 6 months, then I will advise, okay, fiancé visa is fine.
If the person is not already married, what would be the first steps in order to bring over the fiancé? If you wanted to have a marriage in the United States.
Sure. The first step starts over here. then you have to file your petition on the form I-129F to one of the service centers, like where you are living. So, if you are living in Maryland or Virginia, then the jurisdiction would be Vermont Service Center. So, you are filing I-129 petition to the Vermont Service Center, and they may take about 4 to 6 months, again depending upon how many applications are pending. And once it is approved, then it goes to the National Visa Center. So, first step is always to file the petition with the service center of the USCIS. And let me explain to you, Ken, at this point it's very crucial that you need to establish that she is your fiancée. So, you have to prove your relationship, and one of the major requirements is that you must have met your fiancé during the last 2 years, unless this is waived under special conditions. And second is that you are eligible legally and you are willing to get married within 90 days after your fiancé lands here in the US. And then of course, you should be in a position to support her financially, so that that person who's coming here doesn't become a charge on the state.
Seems rather unfair within the context and view of certain cultures where people might have arranged marriages and they might have been arranged since childhood to get married later on when they're adults and had even known each other, might have even been second or third cousins.
No, that's very true, but you have got to prove it, that you met with your fiancé during the last 2 years. That is the requirement, unless it's waived under certain situations.
Can you get it waived if,
yes,
if you
yes.
can show that there was a legitimate intended marriage set up by families, 5-10 years ago?
You know, I don't think that is the basis for waiver, but there are 2 grounds upon which you can seek the waiver. Let's say your traditional customs don't permit the boy and the girl to see before marriage. There are certain countries which don't permit. Now, second would be if it causes extraordinary hardship to the US citizen, not to the alien who is to come, but if it causes extraordinary hardship to the US citizen, then it can be waived.
What would extraordinary hardship constitute? Because presumably that's just not having a broken heart, or else it apply to everybody.
Right. So, there could be various situations which you have to document very well. Let us say that US citizen is having backache and this person cannot travel. Doctor has advised this person that you cannot travel to a foreign land which is about 18-hour journey, and otherwise your back will not cooperate with you. So, this is a medical situation which he can document very well with a note from the doctor, I cannot travel and I want to get married. This is one of the situation. Or that person's work situation is such that he cannot get any vacation time, not at all. But the burden is very heavy to prove this is what it is, and I cannot go, let's say fiancé lives in India, I cannot go to India, or I may lose my job. I already took my vacation because I was sick. If I apply for vacation now, I lose my job, financially I will be wrecked. You know, all these kinds of situations have to be documented very well, and if really causes the extraordinary hardship, then the requirement of having met with during the last 2 years, that can be waived. But again, going by your comment, you are proving it, that before 2 years when you met and how intimate was that relationship, you have to document by way of pictures, by emails, all that kind of stuff, whatever you can collect.
So you'd use that type of document to prove the existence of a relationship with the fiancé?
Yes, like if you are exchanging emails every single day, like it's just like writing your personal diary. So you are saying, oh, what did you eat for your dinner? I ate this. Okay, I ate this. When did you go to bed? I went to bed at 11 o'clock. What about you? And early in the morning at 5 o'clock, fiance sends an email, good morning, and he responds, good morning. You know, that kind of intimate relationship. If you can document it, it will go a long way. Sure.
And you could probably even document that it evolved from just a casual meeting on the internet to a full blossom love.
Oh, sure, sure, definitely. And maybe you met last year, let's say you are not seeking the waiver, but you are documenting your relationship, and while you met with her in India, you decided to go on vacation to the neighboring country, Nepal. So, you are documenting your hotel receipts, and you are providing some pictures, what was the date the picture was taken, where the picture was taken, maybe there were some other friends or family members who are also in the picture. So, that way you can document that this is how you were spending time together, and that shows that you have that kind of relationship. Any reasonable mind would believe, yes, there is a strong relationship.
How long is the K-1 visa good for?
You know, once the K-1 petition or visa is granted by the US consulate, because always visa is issued at the US consulate only, then you have 6 months to come to the United States. And of course, I told you one more deadline. Once you are in the United States, you have to get married within 90 days to the same person who sponsored you.
So the same person?
You can't change the person.
Wow. That's going to be a bummer for some people.
Yes, yes, yes.
Once you're in the United States and you have the K-1 and you're married, you know, I would assume that you stay on the K-1 until you get an adjustment?
Yes, but remember, this is valid for 90 days because you have to get married. In fact, they say you have to get married. So, once you have gotten married, file for adjustment of status, which is a green card application.
Does that adjustment itself grant a person the right to stay in the country?
Yes. In fact, this is called the change of status from K-1 to green card, and you will be filing change of status application or adjustment of status I-485, then you are filing I-131, and you are also filing your medical report. In fact, it's already filed, but if time period has elapsed, probably you have to file it again.
So the fact that the K-1's already expired is no hindrance for you to continue on in the country?
Because entry or admission to the United States was legal.
Very good, very good. If the couple does not get married, how long can the fiancé stay in the country?
I would say there is no grace time. If you are not getting married to the US citizen who petitions for you for K-1 visa, better you pack up your boxes and go back.
Wow.
You can't stay here. Your stay is already illegal. And you cannot say that I have changed my mind. I am not getting married with another person. Sorry, you are out of luck. You have to go back to your country, and if you have found some other person, then you have to apply, that person has to apply for you.
Wow. That's interesting. So you can't just change your heart
No,
overnight and have immigration to accept that.
You can't.
Even if you get married.
Yes. The funny thing is, though K-1 is a non-immigrant type of visa, but it is processed as an immigrant visa because that's the way the nature of this petition is.
Very good.
Because like I said, both of you are able and willing to get married in 90 days. And that is the requirement that you are getting your K-1 visa.
Apparently to the same people too.
Yes,
so the best man can't run off with the bride.
Yes.
Well, that's interesting to know, and I really like to thank you for coming in. I'm sure this has been most informative for people. You know, it's close to everybody's heart, I think. We can all relate to it, and thank you very, very much.
Thank you very much, Ken. I appreciate that. And again, just a suggestion to the audience, whenever you have some immigration issues, talk to your immigration attorney. And that's the best way to go about the immigration issues in this complex world. Thank you very much for being with us. And thank you, Ken.
Thank you.